Here's how to navigate probate in Missouri, what you need to know. Have you recently lost a loved one and are now facing the daunting task of dealing with their estate? If so, you are not alone, and understanding the probate process in Missouri can make things a lot cleaner and a lot more manageable for you. Now, today we're breaking down the basics of probate in the state of Missouri, why it matters, and how you can navigate it with less stress and more confidence. So, first of all, what is probate, right? So probate is the legal process where when somebody dies with property in their name and without a beneficiary and or a transfer on death designation, or without certain kinds of joint ownership or a trust, property that's left in their individual name and has nowhere to go, there has to be a mechanism for transferring that to the heirs. And that mechanism in Missouri and in all states is called probate. It's an in-court process. Okay, so we have to go through that process in order to properly transfer ownership of assets belonging to a deceased person. This may be distributed according to their will if they have one, or according to the laws of intestacy if they didn't have a will. And that's basically just the default will that the state gives you if you die without a will. So the property that can be transferred includes things like real estate, vehicles, bank account, brokerage accounts, all kinds of different things that we see in our practice. Here's kind of a step-by-step overview of what you can expect through the probate process. So the first thing in the state of Missouri is you've got to determine what kind of probate is appropriate in your circumstances. So if the assets are over $40,000 and it's within 1 year of the date of death, then typically we're going to be looking at a full estate administration. What does that mean, a full estate administration? Well, it means that we have to open a formal probate. We have to file the right paperwork. We have to appoint a personal representative, sometimes referred to as an executor. And this is the person that steps into the shoes of the deceased and can then manage their property, go to the bank, deal with anything that they have to deal with, pay debts and creditors. If we're over 40,000 and within a year of death, we're looking at a full probate administration. Those can either be independently administered without court supervision for every step, or supervised, which is often necessary whenever the heirs are not getting along. And in a supervised administration, you typically do have to get a court order for everything, to sell anything, to buy anything, to mortgage anything, things like that. Now, in a full estate, the first step is getting a personal representative appointed. And that can often be a little bit difficult sometimes. It depends on the family, depends on the representative. Typically, they need to get bonded. They have to buy a surety bond to protect the estate from mismanagement or theft or anything like that. Typically, they need to have a copy of the death certificate. They need to be otherwise qualified. They can't have a felony background in most cases. And they have to otherwise be underwritten for the bond, which usually means that they have to have decent credit. Not all the time, but most of the time there needs to be kind of a financial threshold there, which is unfortunate and frustrating for many of our clients, but that's the reality of the law in the state of Missouri. Once a representative is appointed, the court's going to issue letters of administration or letters testamentary. This is the magic seal of approval that the court gives you to then go to the bank, go to wherever you need to go to transact business on behalf of the estate, sell the house, sell the car, and so on. The first thing that needs to be done after appointment is within 30 days, the property of the estate needs to be filed on an inventory. We need to collect all that stuff up, figure out who owns it, what is it worth. We need to get the Kelley Blue Book values. We need to get the house valued and so on. And we provide that to the court that says, look, judge, this is what we've got. Here's what we're dealing with. And it also tells creditors of the estate whether there's any assets to go after. Okay. Then in a full estate administration, we're looking at a 6-month window where we have to wait for creditors to file claims if they want to. Okay. When I say creditors, I mean people who think the deceased person owed them money. Could be credit card companies, healthcare companies, friends of the family, friends of the deceased who they believe owe money to them. Now, many times these claims can be thrown out in the state of Missouri. Routinely, credit card companies, healthcare companies, and so on, they hire third-party debt collectors who don't properly follow the steps to getting a claim properly paid in court. So one of the things we tell clients in Missouri is to don't pay anything. Don't pay any debts until you talk to us about whether it's a valid debt or valid creditor. There can be exceptions for paying things like mortgages and utilities, if we're trying to preserve an asset from forfeiture or foreclosure, or if it's the winter, we don't want the pipes bursting, things like that. We're managing the assets, selling things off. If creditor claims are being filed, we're trying to field those and see if we can get rid of them. Now, once all that is done, we move on to distributing whatever is left over. But before we can do that, we have to file paperwork with the court, get everything approved. We got to document what we did or get signed waivers from all the heirs. There are lots of steps involved before we can pull the money out of the estate. Now, this is generally the process for a full probate administration. There are short forms in the state of Missouri. So if assets are under $40,000, oftentimes we can file a small estate affidavit. Now, this can typically only be filed by heirs of the deceased. We can file for special kinds of applications for surviving spouses or minor children of the deceased or creditors of the estate. This works very well for small claims. So like if you've got a car worth $2,000 or a bank account with $3,000 left in it, and you have a funeral bill for, let's say, $5,000, you have a creditor claim for that funeral bill against the estate. And you can often claim the assets of the estate when they're small enough under a creditor's refusal of letters application. There are also other procedures. So finding which bucket you fall into is the first big hurdle, and figuring out what the appropriate type of case to proceed under is. So in order to ensure that this process is as smooth and efficient as possible, we definitely encourage you, and in most cases, unfortunately, you have to talk to and retain an attorney to go through probate. There are certain exceptions for certain kinds of creditor applications or spousal applications, but most applications have to be filed by a lawyer. So find somebody in your area who knows these rules, knows these laws, and can move through the process efficiently. It's ideal if you have somebody who specializes in estate planning and probate, because generally speaking, they are going to understand the process better and how to get things through more efficiently. Another thing to do is to stay organized. So keep track of anything you spend, debts, any bills that you pay, anything you pay out of pocket, either on your own behalf or out of your own pocket, or pay out of the estate's assets. Keep careful track of that. Keep track of your receipts. We provide all of our clients with an Excel spreadsheet to keep track of everything so we can easily sum all that up. And in addition to that, it's important to keep open lines of communication with the heirs, if there are other attorneys involved in the case. Keep open lines of communication about what's going on so that you can mitigate any hostility and confusion. One of the biggest problems that we see in so many probate estates and in our trust administration and just the general process of somebody passing away is that people just don't trust each other. And most of the time it's because of poor communication. They just don't know what's going on. They're confused, and if they don't know what's going on, people tend to jump to the worst and assume the worst. So we want to cut that off as much as we can. So we try to bake as much communication into our systems as possible to help make sure that people are staying apprised of what's going on. So if you're dealing with probate in Missouri, remember, you do not have to do this alone. You can make sure you watch our videos, understand more about how to deal with this process and move through it. And if you understand it, it'll make it a whole lot more bearable. So for more insights about estate planning and probate in the state of Missouri, subscribe to our channel and hit the bell icon so you don't miss our next video. And if you need specific guidance on probate in the state of Missouri, contact us at Schnurbush Law. We're here to help you through every step of the process. Check out our website linked below and more resources for information. Until next time, guys, take care.